on the screen up there.
Don't forget to turn on your,
Oh, those are, that's all the
turn on your mics.
ABC
Oh.
equipment
I'll bring this down here so I can be as loud as ever.
over there, so we have a big
All right, Andrew, you, can you hear me?
Yes, I can.
All right, so we're gonna start the Marshfield Zoning Board of Appeals meeting February 27th, 2024, because I'm probably too close to it. It's a hybrid meeting, so if you're dialing in *6 to mute and unmute yourself. We're being taped by MCTV if anyone's interested. And do you see, hold on, so we have to do a roll call, Larry.
Larry Keane here.
Robert Hensley here.
Brian Murphy here.
Heidi Conley here. Jean Lee here.
Brian?
He's connecting to audio right now.
Oh, okay.
Andrew, can you hear me? This is Brian.
We can hear
Yeah, we
you.
can all hear you now, yeah. Thanks, Brian.
Thank
Loud
you.
and clear.
Brian, you just gotta say you're here, obviously you're here, but,
Gee whiz, yeah, Brian Sullivan here.
all right, so for tonight's meeting, I'm just gonna quickly announce the ones we're continuing, and then we'll go on to the others. So, D, 2416, Scott Shanley, in accordance with 305-1009 of the Marshfield Municipal Code, petitioner is seeking an appeal of the building commissioner's determination that a commercial kennel and dog training daycare has been added to this residential property, which is in violation of 305-502 permitted uses, 305-504 table of use regulations, 305-1107 home occupation of the Marshfield Municipal Code, and the property is located at 283 Holly Road, which is further identified on the assessor's maps as being on parcel H140302 and is located in the R1 zoning district. So we're going to continue that to 326.
Second.
All in favor? Oh, second. Heidi, all in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Heidi Conley, aye. Jean Lee, aye.
Brian Sullivan, aye.
Okay. And now we have Amy Gilliman, 2386, is going to be continued to 326, 556 Pleasant Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Heidi Conley, aye. Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Patrick Campbell, 2395, 1067 Union Street, being continued to 326. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Heidi Conley, aye. Jean Lee, aye.
Brian Sullivan, aye.
And 2406 Nicole DiPaolo, 71 Furnace Street, is being withdrawn without prejudice. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Heidi Conley, aye. Jean Lee, aye.
Brian Sullivan, aye.
Did I do Kevin McDonough? Oh, and Kevin McDonough, 2387, 53 Juniper Road, is being continued to 326. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Robert Hensley, aye.
Brian Murphy, aye.
Heidi Conley, aye. Jean Lee, aye.
Brian Sullivan, aye.
So we
Thank you.
have 4 continued and 2 new on the 26th?
Yes. No, the 26th, not the 12th. So now we have 2413, Richard M. Clements. The petitioner is seeking a special permit under 305-902, 305-1010, and 305-1012 of the Marshfield Municipal Code to alter and reconstruct the second dwelling in the center of the lot to eliminate the dwelling setback nonconformity by constructing a 77-foot by 28-foot dwelling with an attached 3-car garage, and to convert the existing second dwelling on an accessory building on the property located at 16 Old Summer Street, which is further identified on the assessor's maps as being on parcels F170307C and is located in the R1 zoning district. Name and address for the record.
All right, fantastic. My name is Jeff DeLisi. I'm with the law firm Morenberger, DeLisi and Harris out of Situate. I'm here with my client, Rick Clemens, who is the owner of the property. He's sitting to my left. Mr. Clemens, as I indicated, owns 16 Old Summer Street. The property is located in the R1 zoning district. It being 4.4 acres is more than 4 times the 1 acre requirement of square foot otherwise required in the zoning district. There are presently 2 dwellings on the property in the zoning district that only allows each property to have 1 single-family dwelling. A bit of history, the Reeves bought this property in the 1940s and lived at the smaller of the 2 houses on the property while they built the larger house. Both structures went through additions over time, and the assessor record characterizes both dwellings as separate 1-family dwellings. The smaller dwelling, which is the focus of this application, has full facilities. It has a kitchen, a bedroom, water, septic, oil, heat, and has been rented to various tenants over time. In a letter dated June 23rd, 2023, written by Attorney Guimond on behalf of his clients, the neighbors, the Daniellis,
Recording in progress.
there is a recognition of the fact that this second dwelling had been previously rented out to tenants of the Reeves family, the tenants being Eleanor Cliff and a gentleman named Manny, who is identified as a, quote, tenant of the Reeves family. Recently, the smaller dwelling that is on the property was reconstructed within its exact footprint after a tree had fallen and demolished it. In addition to it being a non-conforming use, the smaller dwelling is a pre-existing non-conforming structure because its southeasterly side yard is set back 7.1 feet in a 20-foot zone. We're here tonight seeking a special permit to alter and reconstruct that smaller dwelling as a single-story, 1-bedroom retirement home in the center of the lot in a manner that will meet all required setbacks, thereby moving the existing dwelling use further from the property line. That would require a special permit. As for the existing dwelling as it exists today, the kitchen will be removed from that dwelling entirely, and the building would be converted to an accessory building, presently contemplated to be an artist studio, which is an accessory use allowed as of right under the zoning bylaw, item 4 of your zoning chart of accessory uses. So there is some relevant zoning history concerning this property, which I do think that the board should be aware of. And while you do have the zoning decision from 2022, you don't have the letter that was written by Andrew Stewart that resulted in that decision. I'll just give you a copy. It's a 2-page letter, and there's written language on both sides of the paper. In that letter, this smaller dwelling was established as a pre-existing non-conforming when the building commissioner determined in the first full paragraph on the 2nd page that it is my opinion, quote, that the use of this cottage cabin as a residential dwelling was a non-conforming use of a building. In that determination, the building commissioner went on to determine that the residential dwelling use had been abandoned. And the question of abandonment was thereafter considered on appeal by this board, which overturned the building commissioner on that point. However, the board did not disturb the building commissioner's determination that the structure was a protected residential dwelling. In reviewing the materials provided from Nancy, which were provided to the board, I note that there appears to be some confusion as to whether the second dwelling is protected as less than a dwelling, such as a pre-existing non-conforming accessory dwelling. And I'd like to address that point briefly. Your zoning bylaw does not have any provisions regarding detached accessory dwellings. There is no zoning in the town of Marshfield for that. And therefore, it is impossible to be non-conforming to the current accessory dwelling regulations, because there are none. In my opinion, this has to be looked at in the context of what the current bylaw allows and does not allow, and the pre-existing non-conforming use to be determined based on that. And what your zoning decision said, and what we are going on, is that the bylaw does not allow more than one-family dwelling on a property. And that is what this property is protected from. There is no definition of the word accessory, no definition of the term accessory dwelling in your definition sections of the bylaw, but there is a definition of the word dwelling. That definition is that the structure is to be a permanently fixed structure containing a dwelling unit or dwelling units, which this structure qualifies as. The decision from the board in 2022, from the building commissioner's abandonment determination, is that the residential dwelling was a non-conforming use. That's what your decision says. That decision became final, and it was recorded at the Registry of Deeds and cannot now be changed or collaterally attacked. It's established as fact. The characterization that the smaller dwelling is a cabin or a cottage does not place any lesser status of this structure as a single-family dwelling use. The zoning bylaw makes no distinction for cabins or cottages. There are no definitions for those. And this situation, in my opinion, is no different than the many cottages that existed or exist down in Brant Rock that now are used as full year-round residences. So once the board accepts and recognizes the finality of the 2022 decision that validates the determination of the building commissioner that the dwelling was actually pre-existing non-conforming as a second dwelling, then it is well within the jurisdiction of this board to issue a special permit pursuant to section 1012 for an extension or alteration of a non-conforming use. So the bottom line here is that the reconstructed second dwelling, if allowed, will conform with all setbacks, whereas presently it does not. There will be no net increase in the number of dwellings. We'd be going from 2 dwellings to 2 dwellings. There will be no net increase in the number of bedrooms unless the board were in the future asked to consider a modification. And the septic system will be able to accommodate the new structure. So with all of that, I just wanted to make one additional point, and that concerns what would happen in the case if the ZBA were to deny this special permit today. In all likelihood, what would happen is that something very similar to this would be built in any event on the property, because we would be able to divide the property pursuant to the exception of the word subdivision under Mass General Law, Chapter 4181L, and then build a house on the separate lot that would be created. And that separate lot would be separately alienable. And so we're not seeking permission for that more audacious scenario. We're just simply seeking to build a retirement home for Mr. Clemens that is to be a 1-story home with an open floor plan with 1 bedroom. And that's pretty much it.
Okay, thank you. Bob, do you have anything to offer? Seeing that there's nothing. Andrew, do you have anything to add?
The only thing, I mean, I don't know what determination he's referring to. I don't have any of that in the file here to display. so I can't really speak to what they handed you guys. But I don't agree, you know. That's why I initially said it was, the use was abandoned. I've said it was a non-conforming structure and a non-conforming use from day one. I haven't changed my opinion on that. So that's kind of where I'm at. I gave you all my notes already.
All right, thank you.
Brian, I'm here now.
Okay. Go
I
ahead.
couldn't unmute myself fast enough. You know, I think it's up to the board to decide whether this was a more in the nature of an accessory apartment, which does exist under our bylaws. We have a specific section. It may not be attached as in a manner that would comply with our bylaws, but I think that's the question that the board has to answer. Because if it was an accessory apartment, and we also have accessory buildings in our bylaw, then, you know, those aren't necessarily prohibited, okay? The prohibition in the bylaw is against two principal residences on the same lot. And in order to find that this was protected, the building commissioner would need to be satisfied, or the board would need to be satisfied that there were two existing principal residences on the lot. And accessory, in my view, means incidental and subordinate to the principal use of the property and not having separate legal existence. So, you know, I think that's the inquiry that the board needs to focus on.
Okay. Jane, do you want to speak?
My name's Gene Guimont. I'm here on behalf of Kurt Mustonen, one of the beneficiaries of the Alice Mustonen Irrevocable Trust. They own 35 Cornwell Hill, direct abutter.
Do you mind speaking up just a little?
Sure, direct abutter through the side yard setback. I wanted to address two statements that Attorney DeLisi made relative to the finality of the board's prior decision and also the 81L concept. If you recall, in Chapter 40A, subsection 7, there's two different statute of limitation periods. One is a 10-year statute of limitation, and one is a 6-year statute of limitation. The 10-year statute of limitation is you can't bring an enforcement action against a structure that never received a permit, is improper, and has existed for 10 years. The 6-year statute of limitations actually can be brought against a structure that inadvertently or by mistake or just by sheer error did have a building permit issued against it. So there's no finality in that. Relative to an 81L division of land, because technically it's not a subdivision, under the 81L concept, you would have to show the two structures pre-existed the adoption of the zoning bylaw. To date, the only thing we have on record relative to the cottage, the alleged cottage, was that it was built in 1961. So I'm not even sure you could get there with the 81L concept. My client believes that the board should deny this application due to the fact that the zoning bylaw really doesn't allow for what is being attempted. We don't believe that the structure in and of itself has any protection as a pre-existing non-conforming structure or use. The whole concept behind that is that you have to pre-exist the prohibitions that don't allow you to be used. I've submitted data in my record that shows that. The third reason for the denial would be that even if the board got through those first two concepts, you'd have to find that the special permit and what they're asking for isn't more substantially detrimental to the neighborhood. And if you see that relocation, the Exhibit K that I provided in my letter, it shows how this house plops basically right in between the two adjacent houses. So it crowds and puts things all together as opposed to where it's located currently on the property. As was mentioned, the Reeves bought the properties via 4 deeds back in the 1940s. There were 2 deeds in 1945. There was a deed in 1948 and a deed in 1959. All deeds on record reference the fact that there would only be one residential dwelling built on this property. There are restrictions at that time that were put on by neighbors that sold the property. There was also a water easement that was granted to the Reeves that stressed that it would be used for one residential dwelling property. The private restrictions, as of now, from 1996, have probably expired. However, I can't imagine somebody would build a house in 1950 and then go out of their way to piss off all their neighbors immediately and build two structures. Also, in the agreement that was put on in 1946, the Reeves acknowledged they were going to bring a mobile dwelling, a mobile house to the property so they could construct their main dwelling. And then after that main dwelling was built, the mobile dwelling was going to be removed. I highlighted all those in the deeds that I gave to you. Going on to the pre-existing non-conforming protection, which to me is the most crucial aspect. As I said, you have to be pre-existing a use and a structure in order to get that protection. The fact that something was built illegally or improperly doesn't offer you that non-conforming status and use protection. If you go back to the Marshfield zoning bylaw that was in effect at the time, in 1961, the bylaw didn't allow for one resident on a property. There was also a 20-foot setback from the side yard. So immediately in 1961, if this structure was built and they claimed it was a residence, it was in violation of the zoning bylaw. Now, it might get the protection of the 10-year statute of limitations, so yeah, it can survive, but then you can't take that and use that as a weapon to relocate it to another part of the property to build it larger than the existing house that supposedly it was accessory to. The other fact would be is that if we're going through all the accessory status and everything else, if somehow somebody saw this as an accessory use that was protected under the bylaw, your accessory structure can't be more than 40% of the size of the main structure that exists. The one thing when I read this, honestly, when I read this, I was scratching my head because you're not even relocating the alleged pre-existing non-conforming structure to another location and then building off of it. You're leaving it there. You're building an entirely new house, and then that accessory house you're going to convert. So that means at one given moment, now you have 3 dwellings, because you can't give up that non-conforming status until you have your new house built. So there's no way you can have 3 existing dwellings on a property, and the minute you give up using that cottage as a residence, you lose any non-conforming status protection you claim that you had. I also wanted to note that it appears, and I don't know if normally you read the department comments into the record and stuff, but from what I saw from the Board of Health, Planning Board, Town Council, appears all the submittals from the different departments just all don't think this project as it's proposed right now is a good enough project and that the board should go forward with it. Thank you.
Thank you. Do you want to?
Yeah, that'd be great, thank you. So with respect to the title issues and the restrictions that are referenced in the title, there's no reason to get too much into legalese except to say that restrictions expire after a 30-year period. So none of the restrictions that are indicated or were indicated by Attorney Guimond are actually in existence, even though they're recorded at the registry because they've expired as a matter of law. Secondly, as to the concept of the structure, the smaller dwelling being accessory or not being accessory to the primary dwelling, I believe that Mr. Fragoli's here, who's gonna tell you that he knows factually that that structure existed prior to the house, so it wasn't even accessory to anything that when it was built. It was built first, and that it was built prior to the 1950s. So I think from what I can gather, the reason why the assessor says it was built in 1961 is because there were various additions that occurred to the building, one of which in all likelihood would have been in 1961. So, but we at least have some firsthand knowledge that that it was pre-existing non-conforming, which is consistent with Andrew's determination and with your decision. And as far as the finality question is concerned, yeah, the statute of limitations deals with violations of zoning and the ability to enforce the zoning bylaw against property owners who are in violation. With respect to the decision in 2022, when this board indicated in the decision that this is a pre-existing non-conforming second dwelling on the property, that decision became final. And you can't, Bob will tell you, you can't collaterally attack that or change that. It's final. So when we talk about finality, we're talking about that. And I just wanted to remind the board, yeah, there's an argument of overcrowding. This is a 4-acre lot in a 1-acre zone. This is not a small lot. There is not, I just don't see how the board can see that this somehow would be an overcrowding situation when you're talking about 4 acres. So those are my initial comments. I think if Mr. Fragoli's here, the board might like to hear from him.
Is he here? Oh. Just name and address for the record.
I'm a butter, William Fragoli, 564 Summer Street.
Thank you. Go ahead.
This goes back to when I was 14 years old, so my memory is from that period. And at that time, when Charlie bought the property, there was a temporary structure there that he lived in while he was building the house. I don't recall a mobile home that was mentioned today. And that's, it was the house that they lived in while he was building the other house. Also, I had the privilege of taking the census for 20 years in that area. And I can only disclose what's on the public record, that there were 2 dwellings on the federal map, and there were occupants in those dwellings.
Okay. Thank you. Gene, do you have anything you'd like to add?
Yes, I appreciate what was just said. However, there were no dates that were given as to when the 2 dwellings were there. Also, the applicant's counsel is not correct on the 30 years. It's a 50-year statute of limitations based off the year the restrictions were put on. Any restrictions put on prior to like 1960 carry a 50-year statute of limitations. The one after that carry the 30-year statute of limitations. So I just wanted those technicalities corrected. And also I provided 2 cases in the materials that I gave to you that demonstrate the argument that I'm making relative to the protections of non-conforming status and then the protections not afforded. And one of them is an appeals court decision, so that hasn't been appealed, and that stands as good case law.
Thank you. Bob, do you have anything to add?
No, I think I've said all I have to say. I do think that the division of the land that I spoke about in my notes under Chapter 41, Section 81L is not dependent on when the zoning bylaw went into effect. It's when the subdivision control law went into effect. So even though I've given you my view that I don't think that this project can be permitted as is, I do think that the project could be permissible if the applicant divided the lot with the planning board, where actually all they have to do is record a plan showing two non-conforming lots. And I think they could then come in and have a principal lot on each, or principal dwelling on each lot. So just to me, and I haven't heard the evidence. You're in charge of what you feel is the evidence. I think the threshold question is, were there two principal homes on the lot, or, you know, was there a principal dwelling and an accessory dwelling? And I think if there's an accessory dwelling here, you're not allowed to confirm you're not allowed to make an accessory dwelling into a principal dwelling such that you would have two principal uses on a lot. You'd need a variance then. But I do think the applicant has an end around by using this exception to the subdivision control law.
Thank you.
I'd like to amend what my testimony. William Fragoli, 564 Summer Street.
Yeah.
I said I was 14 years old, but I didn't give you a year. As kids, we used to play up there between 44 to 50 until we got our driver's license. Then we got out of the woods there.
Okay, thank
So
you.
the year is that lifespan.
Thank you. Does anyone else want to speak on this? Anyone from the board?
Yeah, real quick, what would be the negative to an 81L?
Well, I mean, that's not what's before the board at the moment, right?
Yeah.
And I think the negative to an 81L would be more detrimental to the neighborhood than what is in front of the board now, because what it would do would create a separate lot, and I use the word alienable. Yeah, we could do this. We can create a second lot if we could demonstrate that the structures that were, Mr. Fragoli indicated existed in the 40s. If we could demonstrate that, the separate lot we created and then the resultant lot where the existing front house is on, either one of those two lots or both of them could be separately alienable to different property owners, so you can convey them, and you can have multiple families, one owning one lot and another owning another lot. And I think that circumstance, while it would still be permissible, is not the best utilization of this property. I think the best utilization of this property for this project on a 4-acre parcel, and would be doing what Mr. Clements wants to do, which is to have, to retire in that home. And in all likelihood, he'll probably have his children own the front home. So that's the answer.
Now, the existing structure that's there now, what's the plan with that? You said you were going to remove the kitchen. Is it going to be used as storage, as a...
No, it would be an art studio. So
Okay.
Mr. Clements is
What's that?
longtime partner, I believe, not married, right?
Yeah, they're going to leave it up.
She does
Yeah,
artwork,
that's what I
so she would be utilizing the studio for that purpose. So we'd be removing the kitchen and in all likelihood, renovating the inside a bit to facilitate that particular use.
Okay.
Anyone else?
So, the other second septic system was put in when?
We put one, put a new one in, we rebuilt the house this past year. We put a brand new system in, it takes care of both houses. The plan that's up on the screen shows another additional system that would be put in should we build the other house. The house we came in front of you for.
Two septic systems. So
Two
there's,
septic systems.
Yeah.
So
There
there's
will be
one
two.
system, there's
Could be
one
two.
system
Could be
right
two.
now that serves both houses, and it's close to the front house.
okay.
And I believe there needs to be wastewater pumped to it. In this particular case, what they would be doing with Board of Health approval would be creating a separate system for the separate newly constructed or reconstructed dwelling.
So prior to what you did October 2023 or whatever you did it,
There were two systems.
there were two systems.
Yes.
So do you know, were they both put in at the same time? Was one prior to the other
Yeah.
one? Like, where did that come from?
Well, the smaller house had a cesspool
Okay.
that was, ancient, and the reason why I know there was a cesspool is my father used to mow Mr. Reeves' property, and he broke through it with his tractor. So he broke the top, so we had to have somebody come put a new top in, so I know it was on the plan where that cesspool was. The larger house had a smaller tank that was in front of it with a leaching field that was, needed to be replaced, didn't meet Title V. So we rebuilt, put a brand new system in to take care of both houses that are there today.
And there is a little hardship here, kind of like a nuance to this whole fact pattern, is when we were before the board in 2022, at the time, Andrew's kind of central determination was that a building permit had been pulled and then no work had been done on it, and that the permit itself was also abandoned. And the reason why we were before you to rebuild in the existing foundation was because we were able to do that as of right.
Mm-hmm.
And what the whole concept was that, well, Rick initially was kind of considering, well, the reason why he didn't start the work was because of COVID and everything, but he was thinking about, well, geez, maybe what I'll do is I'll just get rid of that entirely, and I will just put the second house in at that time. Like, that was initially what was being kicked around. And what happened is because Andrew's determination was that it was an abandoned use, what we wanted to do was make sure that the use was not considered abandoned, create the structure so that we wouldn't be considered to be abandoning the structure, because we had to rebuild it within the 2-year time frame that the bylaw requires. And now that that's completed, and we poured all the money into that, now we're going back to the initial concept, and that's why we're converting this structure to an artist studio now. Otherwise, if this whole circumstance of abandonment didn't occur in 2022, in all likelihood, we would have just demolished the structure and rebuilt the structure in the center of the lot with your approval as a grandfathered situation, such as what we're seeking now. So, but because of the strange set of circumstances, we had to rebuild in the exact footprint as of right, and now we're doing this.
Any other questions?
No, but I'm glad I missed the first one.
Gene, do you have anything?
No.
Brian, do you have anything to add?
Well, yes, Brian, thank you for asking. Sorry, my camera's not working. Can you all hear me?
We can hear you.
Okay, good. I wasn't sure if I should raise my voice.
Please don't.
I appreciate the points made by the abutters attorney, and I understand their concerns about what is proposed. I disagree with what Attorney DeLisi is saying about the use and all the talk about, well, it's going to be this, it's going to be that. Once we permit it, we can't go on to the property and say, well, you've got this accessory structure. We don't like that you're not creating art in it, or we don't like the kind of art that you're creating in that, or it's a workshop, it's not an artist studio. I mean, once it's there, it's there. The house. Once the house is there, it's there. Now, at the end of the day, you have the net exact same number of bedrooms. At the end of the day, you're going to have, with what the applicant's proposing, you're going to have a single property owner versus the arguably more intense two property owners with the 81L proposal. And the 81L proposal would, through legal machinations in 2-3 years' time and engineering costs, end up in exactly the same spot they would end up in 30 days if we were to approve this, absent an appeal and the legal process. From my point of view, and no disrespect to Attorney DeLisi, he's advocating for his client. I don't care that it's going to be a retirement home or this or that. That to me, that's irrelevant. What I'm looking at are the facts of what is proposed on this engineering plan, which is you have a principal structure, you have an accessory structure. Principal structure has, I believe it's 3 bedrooms. The accessory structure has 1 bedroom. And we've already found that the use was not abandoned. There have been 2 houses. We heard testimony. There are 2 houses in this lot going back however many years, greater than 50, and probably more than 60. And that use was never abandoned. It was the use was conforming. Now the structure may not have been conforming, but the use was conforming, residential to residential. So I am in favor of voting in favor of the applicant's proposal as it's presented this evening.
Okay.
Thank you.
Thank you, Brian. So no one else has anything to add?
In favor or he's not in favor?
He's in favor. So, I'm just going to say we've had several of these things in front of us over the years, and I know that we address this as 2 dwellings on 1 property, and I believe that's what we put in the language of our answer. That's what we discussed that night. The term cottage has been used on this. The other side of town, we have another one in front of us tonight that was prior to this same situation. So, to me, you can parse words with cottage, house, home, but the dwelling term that we used on both, to me, says that there's 2 dwellings on this property. And we have to stick to that, because that's what we said.
Brian, can I make a point real quick?
Sure.
Everybody's talking about the one bedroom dwelling. I just want to point out, this is the only portion of the floor plan we have. It's 1 floor of this. It shows stairs, it shows a screen porch below. There is a definite downstairs walkout level. And just in looking at this 1 floor plan with the Board of Health, you have a master bedroom, which is 1 bedroom, but you also have an office right here, which is considered a bedroom by the Board of Health. It has privacy, and it's its own separate room, so that's a 2-bedroom structure right there, just so you know, at least.
So if the Board of Health has a particular issue with that room and doesn't think that it, or thinks that it would qualify as a bedroom, then it would be incumbent upon the applicant to change the floor plan in a manner that eliminates that specific issue. It's not uncommon. That type of thing happens. The way that they're typically dealt with is entranceways are widened, doors are removed, and things of that nature. The house is built on a slope, and so there is an exit from the basement area to grade and out the back of the house. But the concept of this house is to be a free-flowing, 1-floor structure for basically aging into. And if you think about it, that's really also what, even though, again, you don't have accessory dwelling bylaw, you have an accessory apartment bylaw that requires the apartments to be within the primary structure. This is nothing like that. But if you think about an accessory dwelling, the whole concept is to have a portion of the family live on the property in it, retire, while the other portion's living in the primary structure or whatever it is. Again, maybe it is parsing words. The bottom line is 2 dwellings, 2 dwellings. No increase in the number of dwellings, no increase in the number of bedrooms, 4 acres. And the dwelling use would be in the center of the lot as opposed to right 7 feet off the property line. So those are kind of my points.
Okay. So Andrew, they could make sure it's restricted to 1 bedroom if this is to be approved?
Yeah.
I can't make that determination. That's all by the Board of Health.
Right.
Okay.
Who won't sign off on a building permit unless that's
We've
done.
had that in front of us before, so. All right, is the board ready to vote, or do we need more time?
No, I think I'm good.
Everyone good? Brian, you ready to vote? Obviously, I think you said yes.
Yes, I am.
Okay, so I'm going to move that we close 2413, Richard M. Clements, 16 Old Summer Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Grove Henslee, aye.
Brian Murphy, aye.
Heidi Cohen, aye.
Jane?
Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Does anyone want to discuss this, or?
So we're gonna have a main building, main house, or whatever- however we're saying that they are. What was approved in 2022?
Right.
That's gonna be what now?
What we approved, from what I understand, I don't, Andrew, is the decision in there? Andrew, do we have the decision from 2022 or 2023?
It's not in the separate thing.
It was part of the application packet.
It
Okay.
is in here,
Yeah.
so.
What are you looking for in it, Brian?
Just what we referred to the structure as.
Let's see, cottage, cabin, dwelling unit, accessory dwelling unit, dwelling. I mean, you guys referred to it as a bunch of different stuff. Primary structures, non-conforming structure,
That's right, I'll just look it up.
cottage, cabin.
All right, Heidi said she's got it in front of her, she's reading it.
So we've all determined that that doesn't matter, because someone lives there, it's a dwelling.
Yeah, that's what.
I can tell you that I never made a determination, in my opinion, that it was a dwelling. It was always a dwelling unit, which is defined under the Mass General Laws in Chapter 40. So that's what I was using as a dwelling unit. Accessory dwelling unit.
Okay.
So, your decision, reasons for decision, testimony from building commissioner was that the use of this cottage cabin as a residential dwelling was a non-conforming use.
I see that, Jeff, but I don't believe I ever said that. We'd have to see the minutes and everything else. That could be just the way this decision was written by whoever wrote it. That doesn't mean that I actually said those words.
Understood. But again, we were appealing your determination email, which I provided to the board, which called it a dwelling at that first full paragraph of the second page.
Oh, Nancy just reminded me, we're actually closed now, so. So is the board ready to vote on this? Oh, Heidi wanted to read it.
Brian, can you provide a date for me on that email? Because I don't have a copy of that email.
7/18/22.
I see 7/16/22.
That was just when it was printed.
Excuse me?
It was a-
7/13/22.
Oh, yeah, 7/13/22.
10/49.
But, you know, I'm sorry.
Yeah, you can't. Are you comfortable? Okay. All right, so I'm going to move in the positive. I'm going to move that the board vote to grant the petitioner's request for a special permit, subject to the conditions. It needs a building permit, a site plan, and a occupancy permit. And
Right, as-built?
and an as-built, yep. And based on the finding that the applicant's proposal to construct a one-bedroom home designed by Rockwood Design Incorporated. You got the date on that, Andrew? I can't see it.
June 22, 22.
June 22, 22, and a site plan prepared by Stenbeck and Taylor. Andrew, can you pull that up so I can't read these little words on who the PLS is on there? You read that date, Larry?
Me.
I see it. That's a different one. That's right. Oh, it's you, so Rick Savant, dated 12/22/23. Being that it is under 30, it meets the standards of 305-902, 305-1010, 305-1012 of the Marshfield Municipal Code to reconstruct a second dwelling in the center of the, and to eliminate the dwelling setback nonconformity at 70 of a building constructing 77 feet by 28 feet dwelling with an attached three-car garage, and to convert the existing second dwelling to an accessory building on the property located at 16 Old Summer Street. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Grover Henslee, aye.
Brian Murphy, aye.
Are we voting to the actual vote right
Yeah,
now?
this is it.
Oh, no, I'm a no.
Heidi Conway, no. Jean?
Jean Lee, no.
Brian?
Brian Sullivan, aye.
Okay, thank you.
So that's-
Brian, it's Bob Calvin. I think you ought to put a condition on this that says that cottage is going to be discontinued as a cottage, and it'll only be an accessory building not available for use as a residential structure.
Okay,
At the time,
I
yeah.
adopt what Bob said.
Yeah, absolutely.
At
Okay?
the time of.
You don't want this being further divided in the
With
future.
another, yeah, I understand what you're saying.
Once it's occupied.
Yes.
Once occupied, okay.
All right, thank you.
So that's 4 yes, 1 no.
Yeah, it was there's 6 members of the board. The 5 voting members are myself, Larry Keane, JJ, Heidi, and Brian Sullivan.
Okay, so it's 4 to 5. Thank you.
Yeah.
Appreciate it.
Jean's the backup. All right, so,
You have to vote to approve any conditions, too.
Vote to approve.
oh, okay, I thought we added those. So I'm voting to approve the conditions that Bob added. Bob, I put in the site plan, all that stuff already.
So that is discontinued
Okay.
as a.
Yeah, last
as a-
condition.
What's that?
Needs to
Yeah.
vote on
I
that.
Oh, okay,
agree with
so we're
that
voting on
condition.
what Bob added.
Just to
Larry
make
Keane,
sure
aye.
it's upon
Just to make sure.
occupancy.
Yep, Larry Keane, aye.
Grover Henslee, aye.
Brian Murphy, aye.
Aye. Aye.
Jean Lee, aye.
Brian,
Brian Sullivan, aye.
thank you.
Thank you.
All right, so now we are on to John M. Sheehan. Come on up. 2414, the petitioners are seeking a special permit in accordance with 305-1012 of the Marshfield Municipal Code to demolish an existing 10-foot by 28-foot. Guys, you gotta go outside to talk, please. Hello? You gotta go outside to talk.
He's yelling at.
The petitioner is seeking a special permit in accordance with 305-1012 of the Marshfield Municipal Code to demolish an existing 10-foot by 28-foot kitchen laundry area and a 12-foot by 12-foot porch and construct a new 10-foot by 12-foot addition, a 24-foot by 24-foot addition, and a new 14-foot by 16-foot porch in the rear of the existing dwelling on the property located at 193 South River Street, which is further identified on the assessors maps as being on parcel 80801 and is located in the R1 zoning district. Go ahead.
Okay, so John M. Sheehan, 193 South River Street. Basically, my wife and I are entering retirement. We now have 9 grandchildren. We moved there, we had 1. So we're trying to just pick up a space for family gatherings, hence the 24 by 24 open concept kitchen family room. Unfortunately, the 2 structures that are coming down are pretty tired. I had Rivermore Engineering from Situate come out, and they politely told me that it was built by some weekend farmers back in the 40s, and it wasn't really worth much value. I worked with Julie Johnson, the architectural designer, and Rivermore Engineering, as well as Morse Engineering out of Situate for the site plan. I was directed to basically offset, move the non-conforming further away so that it would be, I guess, less non-conforming. So we did step it back another additional 4 feet from the lot line. And that's pretty much it. At the insistence of the builder, I came in, I met with Andrew. Andrew said I didn't need to meet with the Historical Commission because that was not an issue. He said as long as I didn't go beyond the boundaries of the 100-foot buffer, I didn't have to meet with Conservation, which we intend not to, we intend to stay out of that area by quartering it off. Andrew did ask me to meet with Board of Health, which I did. I met with those folks. They said it wasn't an issue, but Andrew would be coming down anyway. But Andrew said just to eliminate any issues down the road, I should meet with them. I did. They said it wasn't going to be an issue. There was a new septic system put in 2006 for 3 bedrooms, and then somebody came in after that and actually took away a bedroom, so now it's a 2-bedroom, 2-bathroom house. And that's pretty much all I have to offer. I don't have a lawyer, sorry. I feel kind of lonely here, but.
And who drew the house plans?
Julie?
Julie Johnson.
Julie Johnson, yeah, you said that.
Sorry.
Any questions from the, Andrew, you have anything to add?
Just that I love this property.
It is beautiful. Anything from the board?
Oh, this looks pretty straightforward. It's gonna be nice.
Brian, you have anything to add?
Yeah, I do. Andrew stole my line. Every time I drive by this house, I'm like, oh God, I just love that house. It is picture perfect, and I am struck by what your architect has done. What you're proposing, I think will be beautiful too. And congratulations on the grandkids. I'm sure they're gonna love coming to your house.
Thank you. Now all we have to do is something about the traffic.
Yeah.
Goes pretty quick by the front of the house.
Sure does.
It's all right.
Even though it's 25. So, anything from the audience on this? Seeing that there's none, I'm gonna move that we close. I can't find. 2413, 2414 South River Street. Do I have a second? John M. Sheehan, sorry. Oh, 193 South River Street.
193.
Yeah. Do I have a second? Second. All in favor?
Larry Keane, aye.
Grover Hensey, aye.
Brian Murphy, aye.
Heidi Conway, aye.
Jean Lee, aye.
Brian Sullivan, aye.
I'm going to move that the board vote to grant the petitioner's request for a special permit in accordance with 305-1012 of the Marshfield Municipal Code to demolish the existing 10-foot by 28-foot kitchen and laundry area and a 12-foot by 12-foot porch, and construct a new 10 by 12 addition and a 24 by 24 addition, and a new 14 by 16 porch at the rear of the existing dwelling on the property located at 193 South River Street, which is identified on a plan from Morse Engineering dated 8/21/23, and a plan from Julie Johnson. Do we have the date on that?
Sure, 7/4/23.
7/4/23. For the following conditions, that we have building permit, Andrew, what's the word I'm looking for?
As-built.
Certified as-built.
Certified as-built and an occupancy
Certificate of
permit.
occupancy.
Occupancy permit. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Rover Hensy, aye.
Brian Murphy, aye.
Heidi Klum, aye. Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Thank you.
Thank everyone for the compliments, much appreciated. Have a
Good.
nice evening.
All right, do we have a Stephen Creed? 2415 Stephen Creed, the petitioner is seeking a special permit in accordance with 305-1012 of the Marshfield Municipal Code to construct a 20-foot by 16-foot addition on the rear of the existing non-conforming structure on the property located at 162 Caswell Street, which is further identified on the assessor's maps as being on parcel M050202 and is located in the R3 zoning district. Go ahead.
Rick Savant with Stenbeck and Taylor. Yes, so the applicant is seeking a special permit to construct this addition off the back of his home. The existing home is non-conforming as well as the lot size. The new addition will not create any new non-conformities. It's actually stepped in a bit from Woodchuck Lane and well exceeds the rear setback requirement. That's basically what we're hoping to do. It doesn't make any more non-conformity. We're well under the building coverage on this one. So that's, keep it short and sweet. That's what we're kind of hoping to do on this
Good.
one.
Anything from the board on this?
Nope, this is very straightforward.
Very simple.
Andrew, other than your notes, you have anything to add?
No, this is literally like one of the only places they can put an addition on the house with a special permit.
It's all right,
And it
thank
won't
you.
make it any more non-conforming.
All right, thank you. Anything from the audience? Seeing that there's none, I'm going to move that we close 2415 Stephen Creed. Here's the address. What is the address? Oh, 162 Caswell Street. Do I have a second?
Second.
Heidi, all in favor?
Larry Keane, aye.
Rover Hensy, aye.
Brian Murphy, aye.
Heidi Klum, aye.
Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Thank you. Now I'm going to move that the board vote to grant the petitioner's request for a special permit in accordance with 305-1012 of the Marshfield Municipal Code. To construct a new 20-foot by 16-foot addition on the rear of the existing non-conforming structure on the property located at 162 Caswell Street, which is further identified on a plan. Rick, it's you, right? What's
Yep.
the date?
129/24.
Stenbeck and Taylor, Rick Savant, PLS 124/24?
129.
129/24.
Yep.
And what was, who drew, oh, the house plan was, who drew that?
I'm not sure of that.
Andrew, can you read that since I can't?
October 13th, 2023.
October 13th, 2023. And who's the architect?
JEC Planning Solutions.
Thank you, JEC Planning Solutions. And this will require a building permit, an as-built, and an occupancy permit. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Rover Hensy, aye.
Brian Murphy, aye.
Heidi Klum, aye.
Jean Lee, aye.
Brian Sullivan, aye.
Thank you.
Thank you very much.
Dan, do you want to come up and talk to us quick? Because I think you'll be in and out of here.
What do we do?
He's just telling us what he's doing on his property.
Do we have another meeting?
Oh, I thought
Don't we
he
have
was-
one more? Is this
We
one-
had continued
Is
one.
this one's continued?
No. Heard you.
Next door.
Go ahead. We're just going
Brian,
over.
I'm going to come up real quick for this. Okay?
Sure.
What are we doing?
We're just going over what you,
Say something.
Andrew's gonna walk up here for this.
Oh.
We're just going over what you wanna, I think.
Actually, I'll stay here because we might want to put some stuff up.
So you're here to add, go ahead, what did you want to ask?
So we're looking, so I'm Dan Smith from Smith & Sons, 887 Plain Street. We're looking to add Coyote tractors to our lineup of products over there. Also felling trailers, small trailers to move the tractors. They're small hobby farm type little tractor. I have a pamphlet here if you guys haven't seen it. Right from just over glorified lawnmowers up to, decent sized little farm tractors. So I guess I just wanted to trailers too.
Well, I think you're basically here because with the zoning bylaw change, you now can do this, have this secondary use of right.
That was my
So,
impression.
Andrew?
I'll just explain.
Go ahead,
real
Andrew,
quick.
thank you.
Because I wanted to put this on the agenda as a discussion because we've had previous site plan approvals, basically saying the types of equipment and whatnot. And this would be larger equipment than what we previously had said they could use. Now the bylaw has changed, and I guess ultimately our question was, does the board feel that they need to do any modification of site plan approval to at least have any say over where on the lot things are displayed or whatnot, is really what it comes down to.
All right, thank you.
Does the board feel like, adding this equipment to being displayed on the property, does that require site plan approval or a modification?
He wrote in his notes, but I think it's from last week. Yeah, I mean, we already display stuff up in the front anyway, so to me, I don't see that we have to modify it, but I'd be willing to listen to the rest of the board.
No, every time I go by, he has equipment out front.
It's a beautiful property. You drive on the left side and you have a parking lot full of cars.
Yeah.
You know what's the difference?
Brian, do you have anything to add? Did he leave?
Sorry, it took me a while to unmute myself. No, I think that what he's proposing to do is consistent with what's going on now. And, I think it's important that we support the businesses in Marshfield, in the business district.
Okay, Jean?
I agree.
Okay. Heidi?
So we're saying we don't need site plan approval?
No, we're
Anything
saying
more,
we
he
don't
can
have to
just do it.
modify. Yeah, we don't have to modify it. But we believe it was covered in the original, plus with the zoning change. All right, so do we need to vote on this?
No, it was just a discussion.
It's clarification, that's what I
We were just
thought.
clearing it up with, to make sure that Dan was allowed to continue by right and that I could get him going on his sign permit and everything else that he wants to do.
All right, thank you.
All right,
Thank you all very much.
Thank you, Dan. Appreciate you.
Thank you, Andrew.
Good luck, Dan.
Thank you.
Yeah, good luck.
Take care.
Now that I've completely butchered everything here. All right, 2410 Next Door Realty Trust, in accordance with 305-10-9 of the Marshfield Municipal Code, the petitioner is seeking an appeal of the building commissioner's determination that the property has been modified without approval and that the following prohibited uses have been added to this non-residential property in an R1 zoning district and the Water Resource Protection District. Retail and service use 17, boat marina, boatyard, and accessory use, number 6, storage of more than 2 boats. The petitioner is also seeking a variance under 305-1011 for relief from 305-504, Table of Regulations, retail and service number 17, and accessory use number 6 to allow for the winter storage of boats on the property located at 870 Main Street, which is further identified on the assessor's maps as being on parcel E120303A and is located in the R1 zoning district. Andrew, you want to go on this first?
Yeah, thank you. So like I said, it's in the R3 district and the WRPD. It's a pre-existing non-conforming use as an establishment used for the sale and storage of nursery and landscaping stock, and has an accessory apartment use as well. So within the last 2 winters, a new area of the property was fenced off and seasonal boat storage was added to the lot, which could be considered a boatyard use or an accessory use, but we could, like they said in the request, you can only have storage of 2 boats on a residential property. The property has been subject to several different site plan approvals, special permits, and variances over the years, none of which permit this added use, which was why they received the notice of violation and is why they are seeking some relief from the board here tonight.
Okay,
I've met with the applicants on this, and that, like, I totally understand what they're doing, but it's just something that is not just allowed to just happen. So that's why we're here.
Thank you, Andrew. Go ahead, name and address for the record.
Matthew Gorham, 884 Main Street. I'm also one of the owners of 870 Main Street, along with my brother William Gorham, Next Door Realty. We bought the property back in 2014 from Peter Sullivan, who had the nursery business there. And the fenced-in property, first of all, has always been there even since we bought the property. We did not create that fenced-in area. That's just one thing I want to note. And then we did start storing boats in there a couple years ago, mostly family and friends, and then we started storing other people's boats there, not realizing that we weren't allowed to do it because we thought it was outdoor storage inside the area that Peter was approved to have outdoor storage in.
Okay. Andrew, anything to add?
Yeah, I mean, there was a fence along the backside of ABC, but they gated off the area as well. That's what I meant by when they fenced it in.
Okay.
Yeah, I don't know that it was always a proposed nursery area. It was a proposed storage area as far as boat storage goes. So that's really what it came down to.
All right, so how does the board feel about this?
Is there any distinction between outside storage and boat storage?
I think I talked to Bob about this, and he said the best thing to do would be, Bob said to give the variance would be the best thing, and he felt that because it was a passive use of the property and that they don't have any neighbors on either side of them, and behind them, he felt that that this would be okay to approve a variance toward this, or he said that would be the way to go about it.
Okay.
Mr. Chairman, if I may.
Sure, go ahead.
Christine Stickney, 22 Preston Terrace. We have 2 pictures we'd like to show you. They're area photos of the site.
Well, Andrew has it the same as Andrew pulled up?
Right. But one is from 2019, and if you look at it carefully, you'll see the property was fenced and the gate was there prior to. So that's not something new, as well as the area is the same as it was in 2019. They purchased the property in 2014. The reason that they're here is because of the notice of violation from Andrew, but there's no definition in the zoning bylaw for a boat yard or a marina. There is the only storage that we felt was outside storage and accessory use, which is item number 6 under accessory uses, but it does limit it to 2 boats. So I think that his pointing out the storage is one issue, but as far as a boat yard, only the general bylaws under section 630, which is under the Board of Health, that's where you find the definition for a boat yard, office surfaces as well as storage. This is cold storage from October to June, end of May. The boats come in on a trailer. They're winterized, they're shrink wrapped, all the same color white, and they stay there. Nobody comes and works on them, they're just stored on the property, and then they leave when the boating season starts, which is, say, May or June.
Okay. Andrew, do you have anything to add to that?
Just that I agree that the boat yard is not defined in the zoning bylaw, but the zoning bylaw tells you that anything not specifically defined there, you go to Webster's Unabridged Dictionary and use that. And the boat yard definition is either a marina or an area storing boats, or an establishment storing boats or selling boats, repairing boats. So all of those things, storage, repair, all those things are considered boat yards.
Okay.
Interesting.
Well, that seems to contradict with the general bylaw of the town that says there are services offered. It's just cold storage is what it is, and it happens to be boats. So a storage of a boat up to 2 is allowed as accessory use. This also is a residence 1 zoning, not a residence 3. So it is a larger lot area. And you'll see in the application that we submitted, we calculated out what the lot coverage was for the area within the fence. It's never been totally stored with boats to its capacity. It's had a few boats, and it depends. Some years there's a few, other years there may be more.
And isn't that showing the fence on that plan right there?
Yeah.
That's the original site plan from Peter Sullivan.
So Nancy, what are you saying? The WRPD is,
If you guys grant the variance, they still have to go to planning for a special permit.
what's that?
If you grant the variance, they have to go to planning board for a special permit, because it's located in the WRPD.
Okay.
Their previous owners have had planning board decisions too, so.
Can you say that again, the planning board what?
Because it's in the WRPD,
Yeah,
they need a special permit from planning.
okay.
So previous owners have gone to planning for other special permits for not their business that they're doing.
Oh, okay.
But
How many boats? How many boats are you going to store on there?
We would like to store up to 40 if possible.
How many do you presently have 20?
23 right now.
Yeah. And a good percentage of that is family.
Yes. I'd say about 12 is family. That's how it started.
I-
And they're all on trailers, they're all registered trailers, they're all insured. They're not things that are gonna be abandoned there by people. We won't allow that to happen.
The property did go before the planning board for the Watershed Resource Protection District, and it was issued a special permit, but that was because it was a reoccupying building. If you remember, if you're from the area, it was a Sons of Italy Hall, and then Mr. Sullivan came in and wanted to sell nursery garden stock, that type of thing. So it was because it was a change that it went before the planning board, and also because the parking changed on it. But this use doesn't even put a shovel in the ground. So it won't, although it's in the Watershed Protection District, if you look at the applicable uses, it's not triggering any of those uses.
Was Pamella's fire apparatus building out of there? Point?
Yeah, he was at one point. It was actually a Maynard fire apparatus, and then Maynard sold it to Pamela, and then Pamela, then it went Sons Italy
Yeah.
to Peter, and then to us.
And they actually manufactured fire equipment
Yes.
there, correct?
Fire engines, yeah.
Yeah.
It was a cement block factory originally.
That's going way back.
So we provided in the application to demonstrate that it's always been of a business use. It's not a case where it was a residence that morphed into a business use. It's always been business use in that area prior to 1930.
How long has your family been in business at that location? Not that location, but that area right there?
In that area since the mid-'70s,
70s?
yeah. Around 76, I think.
76.
Yeah.
So, since Bob's at another meeting, would you mind if we continue this so we could hear from him, just so we could get a better decision and move it out 30 days? Would that be okay?
That's fine.
All right, are you guys okay with that?
I'm fine with that.
I'd like to just hear from Bob,
Sure, certainly.
because I'm butchering what he said. All right, what he told me over the phone, but I'd rather him say what he said. So I'm going to move that we continue Next Door Realty Trust, 2410, 870 Main Street to 326.
No.
What?
326?
No, I don't want to go the night of that disaster.
No, there's 4 and then there's 2 new ones,
I
right?
think you'll have 2 new ones.
Plus the 4 that we just continued.
Right.
Yeah, but that's not a lot.
Plus the big dig.
No, this is,
Well, Big Dig's on the 12th.
I'm staying off that.
Oh, all right, then I'm fine. That's
We
fine.
got
I
you.
thought it was the
Doing
same
this.
day. I'm like, are you kidding me?
So 326, 24. Do I have a second?
Second.
All in favor?
Larry Keane, aye.
Lorenzo, yeah.
Brian Murphy, aye.
Heidi Conway, aye.
Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Thank you. So we'll see you on 326.
Thank you.
Do we have anything else?
No, I think that's it.
No minutes or anything?
No minutes.
There's no
Next
finally,
time.
Next time?
Next one have minutes.
Oh, do you want your pictures back?
You can keep those for the record.
Okay,
Today's date.
Thanks.
Thank you.
thank you.
So is that it?
That's it.
Motion to adjourn?
Second?
All in favor, Larry Keane, aye.
Lorenzo, yeah.
Brian Murphy, aye.
Heidi Conway, aye.
Jean Lee, aye.
Brian?
Brian Sullivan, aye.
Thank you.